Hear ye, hear ye, hear ye. The Supreme Court of Texas is now in session. All those with matters to present shall come forward to be heard. Pending before the court is cause number 20-0001, City of Balboa Bay versus Bluth. Before Chief Justice Fleming, Justice Olson, and Justice Aldretti. Petitioner may begin upon instruction from the Chief Justice.
Is the petitioner ready?
The petitioner stands ready, Your Honor.
Okay, you may proceed.
May it please the court. My name is Natsumi Kovi, and along with my co-counsel, Melissa Fulmer, I represent the petitioner, the City of Balboa Bay, in the present appeal. At this time, petitioner respectfully requests 3 minutes for rebuttal.
That's permitted.
There are 4 issues for this court's consideration on review, and I will be addressing the first 2 issues before this court. First, that the motion for en banc reconsideration was untimely and that this court does have jurisdiction to grant the city's petition for review, and that the Court of Appeals did have interlocutory appellate jurisdiction because there is no substantive ruling requirement over a permissive appeal. Ms. Fulmer will then demonstrate that the Balboa Bay's bag ban is not preempted by the Texas Solid Waste Disposal Act, and there is no duty owed to Bluth. Your Honors, this court should reverse the decision of the 15th Court of Appeals for the following 3 reasons. First, the motion for en banc reconsideration was untimely because it should have been filed with the motion for panel rehearing. Second, the petitioner strictly complied with the requirements set forth by the rule, which does not require a trial court to make a substantive ruling. And finally, this court does have jurisdiction to grant the city's petition for review because the Court of Appeals had jurisdiction over the permissive appeal. Now, turning back to the first reason this court should reverse the decision of the 15th Court of Appeals, that the motion for en banc reconsideration was untimely because there was no modification of the opinion or judgment. Now, when we look to this case, Your Honor, the 15th Court of Appeals should not have heard the case en banc because the respondents failed to file their motion for en banc reconsideration timely. To quote Justice Whitehill from the Dallas Court of Appeals dissenting opinion from Cruz versus Ghani, the Texas Rules of Appellate Procedure 49 is an equal opportunity rule, no more and no less. Both of these motions have been treated the same within the courts of appeals and should be treated the same before the court today. The respondents filed a motion for extension of time, not just for the motion for panel rehearing, but also filed a motion for extension of time for the motion for en banc reconsideration. Both of those motions should have been treated equally, and therefore the motion for en banc reconsideration was untimely. Now, I do understand that there is some confusion about why we would be arguing for the motion for en banc reconsideration to be considered untimely. And that is because our position is that the timeline for these 2 motions are not intertwined. So the motion for en banc reconsideration could still be found untimely by this court and should be found untimely by this court. But this court has jurisdiction over the city's petition for review to grant the city's petition for review beyond the scope of the motion for en banc reconsideration. And I'll explain that timeline in a moment, Your Honor.
So, counsel, are you, so your position right now is that it is timely or not timely?
Our position, Your Honor, is that the motion for en banc reconsideration was untimely. And I'll explain why. If we walk through the timeline.
But you've argued in the Court of Appeals that it was timely, did you not?
Your Honor, the record indicates that we did argue that it was untimely. Our position is, as the petitioner, that the motion for en banc reconsideration was untimely because when we look to the determinations by this court, the motion for en banc reconsideration was filed by the respondent, and the motion for en banc reconsideration was ruled in the respondent's favor. Our position today is that the motion for en banc reconsideration should be deemed as untimely, and the decision rendered by the lower court should be the decision rendered by the en banc court should be found as outside of its plenary power and should be deemed as and should be overturned because the court made that decision outside of their plenary powers. And I'd like to break that down a little bit. There's two different ways that the en banc decision should stand. It's first is if it was made, the decision was made within the 30-day period. And second, if that motion was filed timely. Now, the motion was not filed timely because, as I stated earlier, the motion for en banc reconsideration and the motion for panel rehearing should be treated the same. We see that the explicit language of the rules. We also see that through the local rules of the courts of appeals, which state that the two are treated equally procedurally and as far as timelines go. So our position is that, yes, it is an untimely motion and the en banc decision should be rendered as invalid. The only other way that the en banc decision by the 15th Court of Appeals would stand is if it was determined within the 30-day plenary powers. The respondent may attempt to argue that it was made and the decision was rendered within the 30 days. However, that's simply untrue. If we look to the timelines, Your Honor, plenary powers by the rule of 19.1 states that plenary powers expires 30 days after the court's last order. Now, as the city, the last order that we would look at to determine if the city's petition for review was timely would be 45 days after the motion for en banc reconsideration was granted or that the decision was rendered en banc. Whereas the motion for en banc reconsideration's timeliness would be determined off of their last order, the court's last order, which would have been the order denying the motion for panel rehearing. That is why, even though the record indicates that we may have argued at the appellate court that the motion, in fact, was timely, our position, Your Honor, is in fact that the motion for en banc reconsideration was untimely and that it does not affect the city's petition for review because there are other avenues where the city's petition for review is valid and for this court to exercise its jurisdiction over it.
Are you equitably stopped from changing arguments at this point?
No, Your Honor, we are not, specifically because if we look to Texas Government Code 22.001, or if we were to look to the Texas Constitution, any type of jurisdictional argument or any argument that goes directly to jurisdiction may be raised at any point within the arguments, can be raised at any point within an appeal. And therefore, we are asking this court to determine today that the motion for en banc reconsideration was untimely and that the city's petition for review should be granted and jurisdiction should be exercised by this court. Now, going back to the reason why this motion for en banc reconsideration for the motion for en banc reconsideration is being untimely, we asked this court to look at two different things. First, we asked this court to look at the plain language of 49.7, which does treat these two as the same. And the commentary specifically states that Rule 49 is revised to treat a motion for en banc reconsideration as a motion for rehearing and to include procedures governing the file of a motion for en banc reconsideration. That in
Counsel, on Rule 49.7, it uses the phrase when permitted.
Yes, Your Honor.
Isn't it clear reference to Rule 49.5 that says a successive motion for rehearing is permitted only when the panel changes its opinion or judgment?
Your Honor, our position, that's exactly our position. So it was not permitted within this case. And that's exactly why the motion for en banc reconsideration was untimely. We are asking this court to adopt the fact that the two motions are treated the same. And unless there is another extension for time provided by the court for the respondents to file a motion for en banc reconsideration, that it be found untimely. And we can actually look to the local rules of the Texas Court of Appeals, Your Honors. We see that out of the Second Court of Appeals, local Rule 3D actually provides that these motions are treated the same. In the Third Court of Appeals, we find that they are coupled together. We see in the Fourth Court.
Counsel, the 15th Court of Appeals, to my knowledge, has not adopted any local rules. So let's not look at the local rules. My concern is more that we usually imply a motion for extension of time whenever an untimely motion is filed within the period when an extension can be requested. Why shouldn't we imply that here?
Your Honor, it's not that there's an implication that should be implied here. It's the fact that the en banc court did not have jurisdiction to exercise over that motion for en banc reconsideration because it was outside of their plenary powers. As I explained earlier, that 30 days that they have once their last order is rendered the motion for en banc reconsideration determination was 40 days outside of that 30 days. And so even if this court exercised this permitted jurisdiction over the motion or rendering a decision off of that motion, it was outside of their plenary powers. And so they could implicitly permit from that when permitted language. But if they don't have jurisdiction, Your Honor, we would ask this court to go back to the last valid order that was rendered by the court, the last order that was determined off of the last timely motion, which would have been the motion denying panel for rehearing, which actually was rendered in our favor, in the city's favor. And that's why we're asking this court to look at that and determine that it was untimely. Which brings me to my second point, Your Honor.
So is your position then that without an explicit grant of time that there was no possibility of an implication?
Yes, Your Honor. Our position is that because the respondent filed a motion for en banc reconsideration and motion for panel rehearing extension, both, if we look to the record on page 5 to 6, the motion for extension of time was filed for both of those motions. It was not for one. So it can be referenced from the record that the respondent knew that both of these motions should have been filed within that 60-day extension. However, they did not file. They filed 15 days after the order was rendered denying the panel rehearing. And therefore, we are asking this court to look at that and determine that that implicit permission was not there. That determination was made outside of its plenary powers. And that's exactly why the motion for en banc reconsideration was untimely. Which brings me to my second point, that the petitioner strictly complied with the requirements set forth by the rule, which does not require a trial court to make a substantive ruling. Section 51.014D of the Civil Practice and Remedies Code provides two different prerequisites that must be met in order for an order to be valid and confer permissive appellate jurisdiction. First, the order to be appealed involves a controlling question of law as to which there is a substantial ground for difference of opinion. And second, an immediate appeal from the order may materially advance the ultimate termination of litigation. We see that on page 6 of the record provides that the order generally concluded that the order involved a controlling question of law as to which there is a substantial ground for difference, and that the immediate appeal may materially advance the ultimate termination of the case.
Okay, Counselor, is there a single court that has held that the substantive ruling requirement does not apply?
No, Your Honor, there is no court of appeals that has determined that a controlling question of law does not apply to the orders granting permissive appeal. However, we could ask this court to look at the Fourth Court of Appeals' most recent decision rendered on April 1st, 2020, Kenyon versus Elephant Insurance Company, LLC, where the court actually in dicta determined that the Texas Supreme Court and Sabre Travel International Limited has decided that a controlling question of law does not need to be stated. While it wasn't the explicit rule that was stated within that rule, Justice Chapa's opinion references the analysis of the Texas Supreme Court when determining that the Court of Appeals is in fact reading language into the statute that is not present. So we would ask this court to look at this move, or at least the first Court of Appeals that's recognizing that they may have to overturn their prior decisions, that a controlling question of law must be explicitly stated within the order to confer appellate jurisdiction. And another reason why this court, the 15th Court of Appeals, had jurisdiction over this case was is in fact a different rule, Your Honor. Texas Rules of Appellate Procedure 28.3K states that an appeal is perfected as soon as the Court of Appeals, or an appeal is perfected as soon as the Court of Appeals grants the order or the petition seeking review. And so as soon as the motion was accepted by the Court of Appeals, they did have jurisdiction, even if this court were to determine that this order itself did not meet the rules requirements. And for those reasons, we ask this court to reverse the decision of the 15th Court of Appeals. Thank you.
May it please the court, my name is Melissa Fulmer, and I also represent the petitioner, the City of Balboa Bay, in this appeal. Your Honors, this court should reinstate the 15th Court of Appeals original panel decision ruling for the city pertaining to the last two issues. Regarding the preemption issue, the original panel decision was correct in holding that respondent failed to overcome her extraordinary burden and demonstrating that the Texas Solid Waste Disposal Act preempts the bag ban. And regarding the duty of care issue, the original panel decision was correct in holding that Officer Taylor did not owe the respondent a duty of ordinary care. Your Honors, turning back to that preemption issue, there are two reasons that this court should hold the bag ban is not preempted by the Texas Solid Waste Disposal Act. First, the respondent failed to demonstrate that the legislature intended to preempt this ban with unmistakable clarity. And the second reason that it is not preempted is because City of Laredo versus Laredo Merchants Association is distinguishable because this ban was not created for solid waste management purposes. Your Honors, this court has long established and long respected the ability of cities like Balboa Bay to create reasonable ordinances that are intended to protect and support the comfort and welfare of its citizens. That is why this court imposes what the court described in Hunt versus City of San Antonio, an extraordinary burden for any who challenges the preemption of a local ordinance. And here, that is where the respondent fails. The respondent failed to overcome that extraordinary burden in demonstrating that the legislature intended to preclude all bag bans, such as the one in this case. This brings
Counselor,
me
I
to
want to ask you about Laredo Merchants. In that case, we noted to discourage use of these bags, referring to plastic bags, the ordinance made it unlawful for any commercial establishment to provide or sell certain plastic or paper checkout bags to customers. Isn't it true that both here and in Laredo Merchants, the local ordinance is to discourage use?
Yes, Your Honor. Both of the ordinances are the same in that they prohibit businesses from distributing those plastic bags at points of sale and checkout. And that is what, but that is not what happened in this case. It's distinguishable because the specific language within the Texas Solid Waste Disposal Act states that cities cannot adopt those ordinances for solid waste management purposes. And reading that language, we turn to the canons of statutory construction and presume that the legislature included every word in that statute for a reason. And here in that statutory language for solid waste management purposes, that is the legislature's limiting language. Thus, the act itself is not an outright ban against all types of bag bans. And that is what distinguishes the ordinance in this case from the one in City of Laredo. The error that Laredo made in its bag ordinance was that it intended to create a trash-free city. And that trash-free city goal was what conflicted with the Texas Solid Waste Disposal Act. However, here the city never asserted that it intended to regulate solid waste management because it intended to create a trash-free city. Rather, the record demonstrates that the city of Balboa Bay has a reputation for being a clean, litter-free city already. Therefore, the council had no reason to create an ordinance that adopted the same purposes as the city of Laredo in that case. Instead, what the council did unanimously agree on was that it wished to promote its highbrow aesthetics, and it wished to eliminate that safety hazard posed by broken shopping bags. And that is what saves this ordinance from preemption. And Your Honors, other city ordinances have existed that did also regulate single-use plastic bags. The city of Austin had an ordinance titled the Single-Use Carry-Out Bag Ordinance that similarly discouraged the use of plastic bags at points of sale in businesses. And the Texas legislature, noticing that bag ban, tried to introduce a new bill that discouraged similar ordinances titled the Shopping Bag Freedom Act. And by proposing that Shopping Bill Freedom Act, the legislature essentially conceded that clearly the Texas Solid Waste Disposal Act is not an outright ban against all types of ordinances, pertaining to plastic bags.
Well, Counselor, you're trying to say that this case that you're here on right now is distinguishable from the Laredo case. Is that right?
Yes, Your Honor.
But in the Laredo case, the bag ban was intended to prevent sewer blockages. And wasn't there also a sewer blockage in this case?
Your Honor, the results of that investigation were inconclusive. So the record does not clearly state that there was indeed a sewer blockage problem. Therefore, the city did not create this ordinance to address that same issue, unlike the city of Laredo in creating its ordinance. And again, what makes this case distinguishable is that the city here never had a problem with managing waste. Its reputation is cleanliness. Rather, the city wanted to promote those aesthetic values. And reading the plain language of the act, nothing in the act prevents a city from enacting an ordinance that is intended to promote the aesthetic and safety values of the city. And that is—
But its reputation was for cleanliness, which means that its reputation was for having trash be properly disposed of.
Yes, Your Honor.
So should we allow the city council to play word games instead of looking at the practical effect of an ordinance?
Your Honor, we're not suggesting that cities should be allowed to play word games. And in fact, perhaps the court in the future would find an egregious fact pattern in which the city is clearly trying to circumvent preemption. But that is not the case that we have before. But
in this case, we don't have the facts because we don't have a trial being held. So what standard are we going to ask the trial court to use when if we decide to remand for a trial? What standard is the trial court going to use to determine whether or not this ordinance was for the purpose of municipal waste management?
Your Honors, the trial court would apply the standard that was set in Hunt versus City of San Antonio by this court, and that is the extraordinary burden standard. And additionally, the court would also apply—
When did we decide Hunt?
That case is from 1971, Your Honor. And since
then— Right, I am fairly certain that in more recent cases, I'm thinking of the concrete cracking ordinance from the city of Houston. I wish I could remember the official case name. We specifically said that we were going to evaluate the practical effect of the ordinance as opposed to letting a city council announce findings or announce reasons in the ordinance that would allow it to dodge whatever standards the legislature had set.
Yes, Your Honor, but that is where we would disagree that the practical effects of this ordinance are to manage solid waste, because here the plastic bags have never yet become solid waste, unlike the ordinance in City of Laredo. And that is what makes this case distinguishable. And until the legislature—
But Lucille Bluth tripped and fell over a solid waste bag.
Yes, Your Honor, but
and then Lindsay Bluth encouraged all the citizens of Balboa Bay to call their council people to pass the ordinance because of the bags flowing into the bay. So why shouldn't we allow some fact finding to determine what the actual purpose of this statute was, rather than just rely on what the city council has said?
Your Honor, looking at past preemption cases, the court does not use a factual analysis on the history behind the ordinance's creation. And that is why we're asking this court to simply look at the plain language of that statute per the canons of statutory construction to see that the legislature included that limiting language. And again, the legislature intended to discourage these bags in further legislation, but that is not, until that happens, this court is not sitting as a super legislature to create or determine that all bag bans are preempted. And Your Honors, I don't want to determine
that all bags are preempted, and I'm not arguing with you over the legislature saying that bag bans are preempted only if they have a specific purpose. I'm asking, who decides ultimately what the purpose is? Do we let the city council say what the purpose is and defer to that, or do we let the trial court engage in some fact-finding in an adversarial test to determine whether or not that's just a pretext?
Your Honor, perhaps the trial court would engage in that fact-finding, but in this case, we have a motion for summary judgment. And viewing the facts within that motion for summary judgment, the respondent failed to overcome her burden in demonstrating that it is unmistakably clear that the legislature intended to do so. And moving on to the fourth issue, Your Honors, there are two reasons that this court should reinstate the 15th Court of Appeals original panel decision in holding that Officer Taylor did not owe a duty of care to the respondent. First, this court has never recognized a duty to prevent unforeseeable injuries to others around them. And second, this court should refuse to create a new duty because the type of injury in this case was too remote and too rare to validate the burden that would be imposed upon Officer Taylor. Pursuant to my first point, Texas has never recognized a duty of care for drivers to prevent or be the absolute insurers of the safety for those around them. And while operators of motor vehicles do have general duties to maintain a proper lookout, that is not what Lucille Bluth urges this court to hold that Officer Taylor violated here. Rather, she is asserting that Officer Taylor owed a duty to prevent her from tripping over a plastic bag in a private parking lot, a bag that was not even branded as a Buc-ee's bag. Simply put, because there is no foreseeability in this case, no duty should be recognized. And that language—
Counselor, isn't the whole point of putting lights and sirens on for a police car to attract attention of others? And wouldn't that make some kind of risk foreseeable with a distraction or something like that?
Your Honor, that is the intended purpose, to distract other motorists, and cases from the Texas courts that recognize that purpose of lights and sirens all pertained to motor vehicle collisions and distractions that are imposed on motorists. But here the disconnect—
Well, I mean, that can't possibly be right, because the sirens are also intended to keep pedestrians from stepping, for instance, stepping into a crosswalk to cross when an emergency vehicle is coming and is going to override the light.
Your Honor, but this is just, we respectfully disagree that this is the same type of case, because here this is an unmarked bag in a private parking lot, and that is where this—
Well, but why does the bag in the private parking lot matter? Why isn't the general duty of care that someone who is driving an emergency vehicle has a general duty to employ their lights and sirens in a responsible manner?
Your Honor, I see I'm out of time. May I answer your question?
Yes, please.
The court, in determining that a duty exists at all, turns on that element of foreseeability. And without that element of foreseeability, no duty can be recognized. And for those reasons, we pray that this court rule for the petitioner. Thank you.
Is the respondent ready to proceed?
Madam
I'm sorry.
Chief Justice, and may it please the court. My name is Brian Pounds, and along with my co-counsel Cody Miller, we proudly represent the respondents Lindsay and Lucille Bluth in today's proceedings. Your Honors, while there are 4 distinct issues before the court today, each and every one of those issues gives this court the opportunity to affirm the principle that our laws function only when they are used as intended. In my time before the court, I will demonstrate first why respondents' en banc reconsideration motion was timely pursuant to Rule 49, and second, why a substantive ruling by the trial court is jurisdictional prerequisite to interlocutory permissive appeal. My co-counsel will demonstrate why the Balboa Bay bag ban is preempted by the SWDA, and finally, why Officer Taylor owed a duty of care to Lucille Bluth. Turning now to the en banc reconsideration issue. En banc reconsideration prevents unnecessary conflicts in precedent. petitioner's construction of Rule 49 would undermine that statutory purpose and result in confusion among the appellate courts. Your Honors, before I get into the bulk of my argument, I'd like to address a couple of points that petitioner made in her time before the court. First, as to this court's jurisdiction, Texas Rules of Appellate Procedure 53.7 provides that a petition for review must be filed within 45 days of the last timely filed motion to the en banc court. If respondent's motion is indeed untimely, then petitioner's motion to this court would have been filed 70 days after the deadline. Therefore, petitioner is requesting that this court enforce one deadline while simply ignoring another. And as the record at 14 shows, this court in that instance would be without jurisdiction to review this case. And second, petitioner misstates Texas Rules of Procedure 19.1. That rule states that a court's plenary power expires 30 days after the last timely filed motion, not just the order. It is a prerequisite that the motion was timely filed. And once again, as the record at 13 points out, the 15th court's plenary power would have expired before the deadline to file a petition for this court. Once again, if respondent's motion was untimely, this court would not have jurisdiction, and it just demonstrates that the petitioner is seeking to enforce one deadline while ignoring another. Accordingly,
how many times in the past have we interpreted an out-of-time petition for review as a petition for mandamus that requires a court to vacate an untimely order?
I'm sorry, Your Honor, could you repeat the question there? I heard a little interruption.
Certainly. How many times in the past have we interpreted a petition for review to be, in the alternative, a petition for mandamus, and the issue is whether or not a court of appeals entered an untimely order?
Your Honor, I'm unsure on that point. I'd have to submit a supplemental brief and get back to you on that. But that brings
Why shouldn't we do that now?
Well, Your Honor, as this court stated, the purpose of Rule 41 the purpose of en banc reconsideration is to maintain uniformity of the court's decisions. And here, respondents complied with the deadline, and therefore this court does have jurisdiction. It's simply my point that if respondents are arguing that the motion was untimely, they would be deprived of jurisdiction. They're simply seeking to enforce one deadline and ignore another. And that brings me to my first point, that the 2008 amendments to Rule 49 demonstrate that Rule 49.5 is inapplicable to motions for en banc reconsideration. Now, Your Honors, because this case is procedurally complex, I'd like to refocus the court's attention to the exact question at issue here. The question is, does when permitted in Rule 49.7 point to Rule 49.5? Because the other requirement is that of 49.7 is that the motion be filed within the 15-day deadline. The record at 6 shows that it's undisputed that respondents filed their motion within that 15-day deadline of the denial of the panel rehearing motion. Therefore,
Counselor, why doesn't the when permitted language in Rule 49.7 refer to Rule 49.11's prohibition against filing a motion for en banc reconsideration after a petition for review is filed?
Your Honor, that's exactly our point. Rule 49.11 is exactly where when permitted points, and that's consistent with this court's precedent and then subsequent amendments to Rule 49 in 2008. Starting with this court's decision in City of San Antonio versus Hartman, this court determined under a prior version of Rule 49 that while motions for en banc reconsideration are related to panel rehearing, they are procedurally distinct. Therefore, in that case, a motion for en banc reconsideration filed after the 15-day deadline was timely because it made no sense to impose an arbitrary deadline on the Court of Appeals plenary power. And therefore, when this court amended Rule 49 2 years later, what they were doing when they said when permitted, what this court was doing when they put when permitted in was referring to 49.11, which was the exact issue that was addressed in City of San Antonio versus Hartman. And further,
so if we were to conclude that both you and the city have presented good arguments, shouldn't we err on the side of allowing a party to seek relief in this court under the arguable interpretation rule or principle?
absolutely, Your Honor. That's exactly what we're lobbying for here, is that and I believe that comes from this court's decision in Verbeek v. Donner, when an interpretation of an appellate rule of procedure is ambiguous and open to two reasonable interpretations, this court should err in favor of granting jurisdiction and not just simply dismiss because of a procedural defect. And that's what the petitioners are asking. They're asking to impose an incorrect reading of Rule 49, but assuming this court finds it correct, a clearly ambiguous reading of Rule 49 in an attempt to dismiss this timely filed en banc motion. And as the Fourth Court of Appeals stated in Cruz v. Ghani, there are a number of changes this court made to Rule 49 in 2008 that demonstrate that only express provisions of Rule 49 apply to en banc reconsideration. But the best evidence of that is the changes made to Rule 49.6, 0.11, 0.8, and 0.12, excuse me for the misorder there. Prior to 2008, each of those provisions referred only to panel rehearing. But after 2008, each of those provisions stated panel rehearing or en banc reconsideration. And that demonstrates that only certain provisions of Rule 49 apply to en banc reconsideration. But Rule 49.5 was not likewise amended. It still only refers to panel rehearing. That represents a conscious decision by this court that Rule 49.5 is not one of the express provisions that governs en banc reconsideration. Thus, as the record at H shows, Justice Malik in dissent, this is the conclusion that the court intended with the 2008 amendments. And that brings me to my second point in this issue, that to apply Rule 49.5 to en banc reconsideration would undermine the statutory purposes of en banc reconsideration. Your Honors, if you looked at Texas Rules of Appellate Procedure 41.2c, it states that the purposes of en banc reconsideration are to maintain uniformity of the court's decisions or in extraordinary circumstances. And that's exactly what happened here. As Michael J. Ritter stated in the Texas Transitioning Judiciary, the purpose of panel rehearing is to correct clear errors by the first panel appellate court, and that creates a correct order of operations. But here, to maintain uniformity of the court's decisions, the respondents filed an en banc reconsideration motion addressing subject matter jurisdiction, which this court knows is never waivable, to avoid an implicit overrule of the substantive ruling requirement that interlocutory permissive appeal applies, which I'll get into the details in my second issue. As the dissent points out in Cruz v. Ghani, there is a proper order of operations. The 15th appellate panel was given their chance to correct a clear error, and then the en banc court got their chance to to maintain the uniformity of their decisions. The rule functioned exactly as it was designed, and it's for these reasons that we ask this court to uphold the 15th en banc court and find that respondents' en banc motion was timely. And now, turning to the substantive ruling requirement of interlocutory permissive appeal. The failure of a trial court to make a substantive ruling on the issues presented before it deprives the parties of their right to for the jury to act as fact finder and unnecessarily burdens the parties and the appellate courts. Accordingly, this court should uphold the 15th en banc court for two reasons. First,
how does it burden the appellate court if the appellate court has complete discretion to deny the appeal?
Your Honor, once the appellate court accepts the appeal, then they have to, as the 10th Court of Appeals in Borowski versus Ayers stated, they have to discern which of the possible rationales, even those that are not that sound judgment-wise, but has to determine which of the rationales the trial court could have made to determine the motion, and then address each and every one of those rationales. And further,
if we're worried about burdens on the appellate court, then why doesn't the complete discretion to grant or deny the interlocutory appeal take care of that? If the appellate court feels that it's too burdensome, then it simply denies the petition to appeal, doesn't it?
Well, Your Honor, yes, in that situation, the court could exercise their discretion, but in the contrary, it still gives the appellate court too much power in that instance to issue an advisory opinion, when the appellate court can go in and pick out which of the reasonings they find favorable, that as this court, or as the 10th court stated in Borowski versus Ayers, that is exactly the definition of an advisory opinion. And as this court has stated in Spear versus Presbyterian, appellate courts don't have jurisdiction to issue advisory opinions. And therefore, when the trial court doesn't make a substantive ruling, it becomes a jurisdictional defect. And
then let me jump from there to the actual language of the interlocutory appeal statute. It doesn't say anything about a substantive ruling, does it?
Your Honor, the words substantive ruling don't specifically appear in the statute. However, the operative word is involved. And as the court in Borowski held, and then the 1st, 3rd, 5th, and 13th courts have all held, an order to be appealed cannot involve a controlling issue of law until there is a substantive ruling by the trial court. And then, for example, in Borowski versus Ayers, the court found that a general statement of denial was insufficient to invoke interlocutory appeal, even though the trial court had identified the controlling question of law. Here, as the record—
why isn't that wrong?
Your Honor—
Why isn't that wrong? We have never required our trial courts to set forth their reasoning in written orders, unlike the federal courts. And as a matter of fact, in our parallel mandamuses that we've had, when we're analyzing whether or not grants of new trial are appropriate, we have looked at the record to determine whether or not there is reason to support the grant or denial of a new trial. Why should we impose a different requirement here?
Justice, as you just stated, it's the record. The record must reveal a substantive ruling by the trial court. And here, as the record from 5 to 6 shows, the record
No. The record has to reflect a substantive issue, not a substantive ruling. The substantive ruling, in my view, a ruling on the substance would be this motion is granted or this motion is denied, as opposed to a ruling on simply on the form, which says, well, this motion was untimely, or I defer consideration of this motion, I delay this motion without prejudice to it being re-urged once facts are more properly developed.
Yes, Your Honor, and that's where we respectfully disagree, and that's what the Borowski court and the subsequent courts have held, is that the record must reveal a substantive basis for the ruling. While in this court, for example, it is a summary judgment motion, so it's reviewed de novo, there are numerous different levels of review and deference that the appellate court must give to the trial court. And where the record doesn't reflect a substantive ruling for that, or a substantive basis for that ruling, the appellate court can't properly grant that deference to the court. And further, it burdens the parties to brief against every possible issue that could have been raised. Instead, the issue—
But that's the same burden. That's the same burden that they have any time that a summary judgment is simply granted without statements given by the trial court, which is almost every grant of summary judgment in the state of Texas. Why is this any different?
That's correct, Your Honor. With every summary judgment, it would be an interlocutory permissive appeal, and the only requirement there is that the record would have to reveal a substantive basis for that reasoning. Otherwise, it results in an advisory opinion by the court. And this brings me to my second point, that the record at 5 through 6 shows that the court relied on a factual dispute as his reasoning for ruling the way that he did. As this court stated in Jelinek v. Casas, the court should not usurp the role of the jury to act as fact finder, and therefore factual disputes are an improper basis for interlocutory appeal, especially when facts are resolved in favor of the non-movement party on summary judgment. It results, I see my time is up. Thank you.
Mr. Miller, are you ready to proceed?
Yes, Chief Justice.
Okay, you may proceed.
Madam Chief, thank you. Madam Chief Justice, and may it please the court. My name is Cody Miller, and I also represent the respondents, Lindsay and Lucille Bluth, in this case. As Your Honor, Chief Justice Fleming and Justice Olson have both pointed out, the merits issues of this case both involve summary judgment. As such, respondents are not asking for this court to decide these issues, but merely allow respondents their fair day in court and for those fact findings to occur. In my time before the court today, I will address issue 3, why the Balboa Bay Ordinance on plastic bags is preempted by the Solid Waste Disposal Act, or SWDA, and issue 4, why Officer John Taylor did owe Lucille Bluth a duty of ordinary care. Turning to the issue of statutory preemption. The preemption clause of the SWDA expressly prohibits local governments from adopting ordinances which restrict the sale or use of containers such as plastic bags for solid waste management purposes unless authorized by state law. And this is seen at Texas Health and Safety Code, Chapter 361, Section 0961. Respondents ask this court to find the SWDA preempts the Balboa Bay bag ban for 2 reasons. First, because the ordinance was adopted for solid waste management purposes, and this court has already found unauthorized bans on plastic bags are preempted by the SWDA. And second, in the alternative, if this court does not find that unauthorized bag bans are per se preempted, then the asserted purposes offered by petitioner for the ordinance nonetheless do not rescue it from preemption. Turning to the first reason, the Balboa Bay Ordinance functionally limits the sale and use of plastic bags for solid waste management purposes and are thus preempted. As Chief Justice Fleming, you pointed out, both ordinances between this case and the Laredo Merchants case only ban single-use plastic bags provided by retailers at a point of sale. Nothing in the Balboa Bay Ordinance proscribes bags used by private citizens that they previously owned. It only affects commercial provision of bags. And like the Laredo case, also, both cities experienced, as the record shows at 4 and 5, some degree of sewer blockages. As Chief Justice Stiles of the 15th Court of Appeals noted in his dissent, seen in the record at page 15, this court has already found such unauthorized plastic bag bans are preempted as shown in the Laredo Merchants decision in 2018. In that case, the court considered a commercial bag ban like the one before it today. Regarding the aesthetic purposes offered by petitioner, this court held that an ordinance by Laredo adopted for solid waste management purposes cannot avoid preemption merely because it has other purposes. And in fact, this court went so far. Yes, Your Honor.
Did we say that bag bans were preempted in Laredo Merchants?
Your Honor, this court said that bag bans for solid waste management purposes are preempted unless they're authorized by state law. Attorney General at the time, Greg Abbott, in 2014, recognized that there are other potential avenues for regulating plastic bags, but that there must be an empowering statute to give municipal authorities that ability.
So, Counselor, I believe we emphasized that the Laredo bag ban, in its words, is not a ban on plastic bags, but it's an incremental implementation plan towards a cleaner city. It seems like we deferred to what the city called its ordinance in Laredo Merchants. The city of Laredo said it wasn't a bag ban, but here the city called it a bag ban. Does that make this case distinguishable?
No, Your Honor. In fact, the Laredo ordinance, the first stated objective was, quote, to promote the beautification of the city of Laredo and work towards a more trash-free city. This is nearly identical to the stated objectives by petitioner of aesthetic values to uphold the beautification of the city of Balboa Bay. And this court held in Laredo Merchants that such beautification is not in itself a justifiable reason to avoid preemption. Rather, it is, quote, a salutary objective which pertains to the ancillary effects of reducing the generation of solid waste, end quote. So this court reasoned that a prohibition on plastic bags that limits plastic bags at points of sale for aesthetic reasons is still a solid waste management purpose because it is a result of the reduction of solid waste. And to your question about deferring to the city,
does the type of aesthetic purpose matter? Because in Laredo, the aesthetic purpose was that they were polluting the city. Here, the aesthetic purpose is that they think they look low class. And they presumably look low class because they are being carried around by people, not because they are floating around, in which case they would look like trash as opposed to just looking trashy. So to what extent do we defer to the city's stated reasons, and to what extent do we allow the trial court to find some facts as to what the actual reasons are?
Your Honor, if I may respond to your question in two parts. First, on the issue of deference, and second, to the issue about the trash. So this brings us to the other holding of the Laredo Merchants decision, wherein this court wrote that the SWDA clearly regulates the manner of regulating plastic bags, and that through the SWDA, the Texas legislature abrogated municipal power to regulate solid waste in the absence of an express authorization. So even if this court finds that plastic bag bans are not per se preempted under the SWDA, petitioner's assertion that the bags are cheap and ugly does not save the ordinance from preemption. The record at 4 shows that, according to petitioner, the only underlying pinnings of this ordinance are that plastic bags are ugly, and having people to use them to carry them out of stores is contrary to the city's aesthetic values, again, emphasizing the commercial use. The Laredo Merchants decision recognized that the SWDA regulates solid waste at any point in the stream, from generation all the way to disposal. It does not need to be discarded for it to be trash. And the Laredo City Council, the Laredo Council argued it wasn't trash, and this court refuted that argument, recognizing the stream of applications of the SWDA. And to your point about deference, Justice Olson, you yourself brought up when petitioner was speaking that preemption does not require, quote, magic words in order to be present, for that to be present in the ordinance. Just because the City Council of Balboa Bay did not put the words solid waste in their ordinance does not mean it de facto escapes preemption. And respectfully, Your Honors, at worst, petitioners' asserted purposes are a mere pretext designed to circumvent state law. And at best, they genuinely are their reasons, but petitioner has failed to identify any authority which expresses it to ban a type of container simply because they find it unsightly. And for these reasons, we ask this court to find that the Balboa Bay Ordinance is preempted by the SWDA. Turning now to the very different fourth issue regarding Officer John Taylor's duty of care. Respondents ask this court to find Officer John Taylor owed Lucille Bluth a duty of care to not operate his emergency vehicle with disregard for the safety of others, for two reasons. One, the duty of emergency vehicle operators to exercise due care is codified in state law. And two, because in light of this statutory duty, foreseeability of injury in this case speaks only to causation, not whether or not a duty exists. Before presenting respondents' argument, there are a few facts the justices should take note of. Firstly, again, this is a summary judgment case. Respondents are not asking that they find Lucille's action is a winner, that she was harmed and that Officer John Taylor was negligent. Rather, we are only asking that Lucille have her proper day in court. We do not need to determine if Officer Taylor breached his duty, merely that as a matter of law, he owed one. Next, Your
Counselor,
Honors,
I'm going to ask you, I'm going to flip what I asked Petitioner earlier. How is it foreseeable that by turning on the lights and the sirens on a police car, that a pedestrian is going to trip over a discarded plastic bag in a parking lot?
Your Honor, this brings me to the second point of respondent's argument, and that is that foreseeability is a prerequisite for the imposition of a novel common law duty. It is not a prerequisite for a legislatively and statutorily codified duty. This doesn't mean that Lucille automatically prevails. She must still show causation, and Officer Taylor will certainly be provided an opportunity to argue a defense that he made every reasonable effort to comply with the statutory duty. Rather, it merely means that in the presence of this statutory duty, the court does not need to consider foreseeability of injury in determining whether or not a duty was owed. Again, foreseeability in the presence of a statutory duty speaks to causation. Texas Transportation Code Section 547702 requires that police sirens and lights be audible and visible at a distance of 500 feet in clear daylight. Put in lay terms, this means they are roughly as loud as a jet engine taking off and roughly as bright as staring into a 1,000 lumen flashlight. The record at 3 shows that Officer Taylor's stop was not job related, and he used his lights merely because he was frustrated with traffic. He was not responding to an emergency. He was not responding to a job-related call. And this returns us to the first point respondent makes regarding the existence of a statutory duty. The legislature of Texas specifically contemplated protections offered to emergency response personnel when they wrote Texas Transportation Code Chapter 546. Section 546002B says 5 distinct scenarios in which an officer is responding to an emergency and must use his emergency signaling equipment. But none of these apply in today's case, as reflected in the record at page 3. The immediate section after that states this chapter does not relieve the operator of an authorized emergency vehicle from 1, the duty to operate the vehicle with appropriate regard for the safety of all persons. This is the source of the statutory duty incumbent upon Officer Taylor. Your Honors, petitioner mistakenly limits the duty of ordinary care to only motor vehicle collisions, and this court has already found officers liable for injuries caused by distracting others with bright lights, as seen in its decision of Ryder Integrated Logistics versus Fayette County in 2015. In that case, a police officer turned his vehicle to face oncoming traffic, and his headlights distracted another driver, leading to a collision. And the officer was held liable by this court. And further, the court did establish that just by shining the lights in that direction, the officer was operating his vehicle. Furthermore, if petitioner continues, yes, Your Honor, I see you're about to ask a question.
Yes, I was going to ask you about community safety. I want to ask you, if we impose this duty on police officers for using their patrol lights and sirens, then subjecting them to liability, does that deter potential law officers or law enforcement activities that make our community safer?
No, Your Honor, and there are 2 reasons for this. First, as I mentioned, with the duty being a statutory duty, Officer Taylor and other officers can still mount a defense that they made every reasonable effort to comply with the statute and only use their sirens with due regard for the safety of all persons. And secondly, because officers are provided heightened protections, if Officer Taylor had been responding to an emergency, Lucille would have to show reckless disregard for safety, not mere negligence. The absence of an emergency here lowers the standard of proof to one of negligence. And returning to the issue of what constitutes operating, petitioner may try to drive that the lights do not constitute operating a vehicle, but the Texas Court of Criminal Appeals in 2012 in the case of Kirsch versus State held unambiguously, operate is not a technical term or a legal term of art. It is a common usage term, and its definition should be determined by a jury. And for these reasons, respondents respectfully ask this court to affirm the en banc decision by the 15th Court of Appeals and remand to the trial court for further proceedings consistent with its judgment. Thank you.
Petitioner, are you ready to reply or for your rebuttal?
Yes, Madam Chief Justice.
I believe you have 3 minutes.
Yes.
Okay, you may proceed.
May it please the court, I have 2 quick points on rebuttal. Justice Olson, you asked me earlier within my argument if the timeliness of the motion for en banc reconsideration, if we were on the other side in the appellate court, and I misstated myself. On page 8 of the record, line 6, it actually states that the city argues Lindsay and Lucille's motion for en banc reconsideration is untimely. Therefore, Your Honors, we have not changed our position regarding the timeliness of the en banc motion. We oppose the timeliness of the motion then, we oppose the timeliness of the motion now. Now, second, Justice Olson, you also spoke about this discretion that the Court of Appeals has in order to exercise jurisdiction over these permissive appeals. We actually asked this court to look at the federal counterpart to permissive interlocutory appeals under Section 28 USC Section 1292B, which specifically stated within Sabre Travel International Limited versus Deutsche Lufthansa AG, which was determined by this court, that is an indication of, or that is something that we would look to in order to determine how the rules within Texas would also operate. Now, 28 USC Section 1292B has been interpreted by the United States Supreme Court to give this discretion, this broad discretion, to the circuit courts within the federal circuits to have this, to make their determinations of exercising jurisdiction or accepting or denying these appeals. And this court held in Sabre International that the Court of Appeals would also have the same discretion to exercise jurisdiction or exercise their determinations over whether to accept or deny those appeals. And for those reasons, we ask this court to reverse the decision of the 15th Court of Appeals. Thank you.